So, welcome to chapter 26. We're almost done, right? Congratulations, you gotten this far. I know you had to put up with me and listening to me constantly, but we're almost there. So, I'm focusing now just on some of the things that could present itself when the petition has already been filed, some of the issues, some of the steps, etc. So, we'll go over that now. First and foremost, the notice system. To me, this is an issue because a lot of times clients say they never got notice. And just depending how the law firm works, whether they send out notice via, just regular mail. I didn't. Well, it's just an extra cost and more time, and I like to be as green as possible. So that's not something that I did. But whatever system you use, just make sure you follow up with clients. And I say follow up because if they miss a hearing, chances are it's not the law firm's fault. It's the client who didn't write it down and is disorganized, but they end up blaming you at the end of the day. And so what happens is the lawyer goes to the hearing and now they have to go back a second time or hire someone to go. And when you ask the client for more money, there starts the conflict. So the simplest thing I did was just simply get a response. I would ask the client, did you receive this notice? Let me know. And then a week later, did you receive this notice? Chances are they replied, but once they said, yes, I got it, of course, that's saved in the system. I can see their response was filed. And if they failed to appear, well, guess what? It's their problem. It's not mine. You do have to charge more to go to these hearings, and that should be included in the retainer agreement. Now, of course, we already did the first class, right? That had to be done right before the bankruptcy petition was filed. But we got the second course that needs to be done as well. Whether it's chapter 7 or chapter 13, those two, that certificate does have to be filed. Now, I put here CCA, credit counseling agency. Some of them might file it for you. I accepted that. I didn't have an issue with it. It does save me time. I still had to go through, make sure, you got to go through your spam box, make sure that the clerk's office sent notice saying that it was filed, or at least follow up. You know, one thing I will say, and I probably said it before, I like to tell clients, this is like do now. You have a week to do it. I didn't give them the 60 days before the, 341 meeting or anything else like that. I said it has to get done within a week. Realistically, 60 days from its filing, it may not get noticed. The client's going to forget. You start running out of time and pushing it. So just tell them a week. Tell them at worst, if anything, I used to push it has to be done before the 341 meeting. Am I lying? Yeah, but you know what? At least no case got dismissed because of it. Now, if it does get dismissed, you see what you got to do here. Depending on the judge, you can probably just file a motion ex parte to reopen it, and then the judge will sign off on the order. It's not a big deal, but again, more time and money. And if it's your fault, even worse, because now you're working for free. Now, when it comes to the trustee, once you've handled a few cases with the trustee, you understand how they work. You know how they want their documents sent, whether it's email, regular mail, yeah, some still do that, or it's uploaded into one of the secured servers, all these different companies that are out there. Whatever the preferred method is, you'll figure it out with time. I like to do is if the case was filed today, I want to provide the documents today. Boom, get it out of the way. I don't have to deal with this anymore. Now, if that's assuming it's a system I can just log things into, a secured site that the trustee uses, that little by little I can send the stuff. If it's something via email, I'm not going to do it, bit by bit, one parcel here, one parcel there, because that'll drive them nuts. I do it, of course, all at the same time. But realistically, you should have all the documents in your hands by the time that bankruptcy petition is being filed. Sure. Are there emergencies and then, that's an exception? Sure. But the regular case, all that information should be there ready to go so that there's no issues. And likewise, once a client hands everything over to you, guess what? It's your responsibility. So the same way we charge clients to go to more hearings, you don't want a client to say, I have to miss work again. Who's going to pay for work? I'm honest. I've done it before where I told the client, hey, this is my bad. How much did you miss today at work? X amount. Okay, here's the money. And I'll just move on. Clients appreciate it. That's the way I run business. People can do whatever they want, but that's the way I did it. My opinion, that just gets me more clients, giving the client a few bucks for the time that they missed at work. Okay. Now, reaffirmation agreements, I have talked about that before. Reaffirmation agreement, first, I mean, I've mentioned unsecured, while rare, that did happen in Miami for a while. But for the most part, we're talking cars and homes. And remember the issues I talked about, the ride through option, and even in Florida, pretty much with mortgages, we let it slide. But remember that that option changes from one state to another, one district to another. So make sure you understand the consequences if reaffirmation agreements are not signed. And as I've said before, not only that, the creditor is not going to report that to the credit bureau. It's a lie. They say that they're violating the Fair Credit Debt and Collection Practices Act. They are not, but that's how they try to get you to force to sign the reaffirmation agreement. Now, you can see here the dates that are required. There are attorney disclosures required. You can find that in the textbook. I took it a step further. I even did PowerPoints. Hey, I'm a professor, right? Why not do PowerPoints? And I did PowerPoints that, honestly didn't take but maybe 10, 15 minutes to prepare, but I sent it on top of that to the clients along with the disclosures just to make sure that there's no issues. They have it there. I'll tell you one little reason why I did it, because clients get that and they send it to other friends and family. Oh, look what I got from the lawyer. And guess what? I just got a referral. So yes, I admit a lot of things I did was just with the concept of how do I make more money off of this situation, just throwing money out in advertising. What are some cheap, quick, easy things that I can do to make a buck? Now, attorney certification. This is the controversial part where it comes to reaffirmation agreements, where I've said before that some attorneys just don't do reaffirmation agreements, period, especially if it's something um, where the asset's upside down, typically a car. You look at it from the lawyer perspective and issues of liability, it makes sense. Why would a lawyer who A is not a forensic accountant not tell a client anyway, listen, I wouldn't recommend signing an agreement to buy something or keep something for 15,000 when the thing is only worth 10. It defies logic. Again, we're not financial experts, but that's why most lawyers won't do it. They're afraid of the liability issues. Again, where I'm from, Miami, it's different. I never saw an issue with that. Are there other districts where lawyers probably get slammed for doing this and the client signs something and then the client pretends they didn't know what they were signing and everything else? Sure. I'm sure that happens all the time. Miami's a little informal, I would say, in that regards. But it's possible one way judges get over this is just by requiring a hearing. Now in Miami, I could tell you I never had hearings. If the attorney didn't sign a certification, then you're guaranteed a hearing. If there was a presumption of undue hardship, then there was likely a hearing as well. Why would there be undue hardship? Well, bottom line is, what are the expenses versus the income? If the client's upside down, there's going to be an issue, right? How can you afford something when the money's not there? How can you pay $500 when you're $200 negative when you're comparing, Schedule I and J? But what normally happens is that there's someone else helping out. Could be a boyfriend, domestic partner, husband, father, whatever it is, where I'm saying my father is, contributing X amount and is paying for it. So sometimes there was only one judge that would do it. That judge would require that there be a hearing just to confirm that the client really understood what they were doing, etc. Not a big deal, a little more time is spent. That judge even asked, your lawyer's not charging you for being here, correct? And since I already knew that, I knew better not to charge. But of course, I did charge for the reaffirmation agreements. I consider that critical. Some lawyers may not put it in their contracts. They may forget to put it in their contracts, but this is the way I look at it. You get the reaffirmation agreement and you get it way before the 341 meeting and you tell the client, come on in to sign this. That's a consultation. That client's going to be there. I want to talk about the case. I'm nervous. And the reality is you're like, your hearing's not for another 3 weeks. Whatever I tell you today doesn't really matter. But that's why I either sometimes had the client sign the reaffirmation agreement or I would just email it to them. I say, hey, look, this is what the terms are. When we go to court, bring your money and also I'll have you sign there. That way I was guaranteed. If not, they come to the office. As I got later in my career, I was only going to the office if I had to. I was old school where maybe you just went to the office every day, whether there was something going on or not. But as I got a little older, I said, yeah, I'm not leaving my house. I like my house. I like hanging out here with my pets. Worked from home remotely way before the COVID pandemic. But I was like, I have to get dressed, go over there. No, no, no. I'm not going to do that. So, and of course, this is what I'm saying. I didn't even have staff because I was wrapping up the practice. But again, if I can get away with it remotely and just tell the clients to bring the money, they gave me the reaffirmation agreement, didn't bring me the money, which that never happened, then I'm telling them, no, I ain't filing anything until I get paid. All right. So keep that in mind with the issues of the undue hardship and making sure that you get paid and you collect from the client and everything else. All right. Now, finally, when we're talking about the reaffirmation agreements, one issue is first, I would say, I put here follow up when filed. I would say follow up before it gets filed. The reason I say that is only one time. It only happened one time, but one time's enough to aggravate you and create a lot of problems. The lawyer sent it to me literally the day, I remember something around 12 o'clock that it expired. And meaning the next day it expired that it had to be signed. And my client was a cop who didn't work anywhere near my office. And he's like, I can't go there now to do this. So I said, okay, don't worry about it. I'll work it out. The next day the client came in. I emailed it to the lawyer. I told the lawyer, here it is. It's a day late because I just got this within 24 hours. And the lawyer, of course, is blaming me, which is beyond absurd and ridiculous. Some people are just jerks that way. And I told the lawyer, and the lawyer's like, well, just reopen the case. I'm not reopening anything. This falls on you. You take care of it. You fix it. So the lawyer kind of drafted some other contract ultimately because he didn't want to reopen the case, probably because the employer, the creditor would find out. But I recommend you put in there a calendar somewhere. Hey, it's Alex's reaffirmation. Have we received it yet? And then make sure that once it's signed and everything else, that it also gets filed because you're not going to file it. You're going to send that back to the creditor. Most of them will take it, just by regular mail. That's fine. I mean, regular email. I'm sorry. Or some of them might require mail like FedEx the next day or whatever. Either way, follow up to make sure that it gets filed. If it doesn't, then we're back to more complicated issues unnecessarily. So just make sure, if there's anything you're going to learn about bankruptcy, because it's so transactional. Documents are due on a certain day, the 341 hearing, the confirmation hearing, the foreclosure date, the repo date. There's all these dates and issues. You have to learn to get organized. And realistically, I learned that early in my educational career, just as a student, trying to depend off my memory and realizing I miss an assignment here or there. So the answer is start writing everything down to make sure you don't mess up. Um, Expenses. I mean, mistakes can be expensive, so it could even cost you your job. I remember years ago, a trial that I was involved in, the paralegal wrote the wrong legal description on a quitclaim deed. And that created a lot of headaches when it came to dividing marital assets on a 1 week trial. And so I could tell you that paralegal lost her job. So keep that in mind. Be organized. Write it down on a piece of paper. If you can't put it on some sort of main calendar system that the whole office uses, but it has to be written down. Okay. So we're done with chapter 26. We're going to wrap everything up now with chapter 27 and then you're all done. Take care, everybody.